Former SAA board chairperson Dudu Myeni returned to the State Capture Commission this week to give testimony, while mainly refusing to answer questions addressed to her. Myeni proceeded to name a state witness known as Mr. X. She said she saw no need for him to give hidden testimony as she knows him and he is like family to her. But evidence leader advocate Kate Hofmeyer advised that Myeni has breached Section 5 of the Commissions Act and said charges should be laid against her. Deputy Chief Justice Raymond Zondo conceded this and told Myeni's legal counsel to submit in writing why Myeni should not be charged by Monday morning. What are the legal ramifications of Myeni's actions, and what does this mean for witness protection in South Africa? So joining me to discuss this further is Stanley Malimacha, an attorney at the Center for Applied Legal Studies. Stanley, thank you for your time and thank you for joining us on Weekend Dawn. I just want to get this out. What sort of trouble is Dudu Myeni in after what she did at the State Capture Commission a few days ago?
Sure. I mean, you know, that is a very important question. You know, look, she's in a lot of trouble. You know, it is unfortunate that in a bid to try and not incriminate herself, she finds herself landing into criminal charges, right? Which is quite ironic because all the time she has been saying, in case I incriminate myself, and you know, when criminality wants you, it will finally catch up with you. So what has happened is that she has contravened the Commissions Act. There's an act that regulates how commissions are set up, and it provides in Section 5 of the Commissions Act, 47 of Act number 8 of 1947. It provides that any person who willfully hinders, interrupts, or obstructs the commission from performing its duties is guilty of an offense and is liable on conviction to imprisonment, a fine, or both. So now this is a clear cut. This is a criminal offense. What she did was committing a statutory offense. Not only did she break a statutory offense, she went further to transgress Regulation 12 of the regulations speaking to the Commission of Inquiry. Now, it didn't stop there. She also contravened an order which was provided by the chairperson. Now, the chairperson provided an order specifically speaking to the protection or the non-revealing of the identity of Mr. X. Now, you know, we must be very mindful that when a commissioner or a court of law, for that argument, gives an order, is that that court was satisfied, or rather the commission in this case was satisfied that the protection of the identity of Mr. X is very crucial to the proper functioning of this commission. And any person, be it the advocate who's leading the evidence, be it the witness that is testifying, anyone who reveals their identity is committing a statutory offense. And I mean, it's a clear cut. It's a statutory offense. It's not like we need to find a needle in a haystack. Yeah. The law is there. It says if you do so and so, you may be charged.
Now, talking about charges, Dudu Myeni's legal team is expected to submit an argument on Monday.
Sure.
Do they have a leg to stand on?
Look, you know, in every legal matter, there's always a leg to stand on. Okay. Just because it is a statutory offense, it doesn't necessarily mean that there's a clear cut. There might be loopholes. But in this one, I really doubt if there are loopholes. Because number one, Dudu Myeni was made aware of the court order. From the beginning? From the beginning. Dudu Myeni, with a legal team on her side, should have been aware of Section 5 of the Commissions Act. She should have been aware of Regulation 12. Now, what is interesting about the provisions of Section 5 of the Commissions Act and the Regulation 12 is that the qualifying word there is willful. So the state, if charges are laid, the state still needs to prove intention. They still need to prove that Dudu Myeni willfully, you know, and intentionally and deliberately revealed the identity of X. So there is a bit of a pinky toe to stand on, but
not a full leg to stand on.
Not a full leg to stand
but the fact that you mentioned that it was intentional, or it was possibly intentional, the fact that she said Mr. X's name more than once, and when the chairperson tried to intervene and stop her from saying it, she continued going ahead. Surely that means more trouble, or that means that it's not even a pinky toe to stand on. It seems as though there's intention.
You know, given the facts, given that she was reprimanded from that particular conduct, and she persisted, there is intention there.
Yeah, with no remorse.
One can readily prove intention. So that's why I'm saying it will be very interesting to see what will be the submissions of a legal team. Because now, here's the thing. Her conduct has, I think, about 3 effects. Number one, it undermines the authority and the duties of the commission. Number two, it places Mr. X into danger. It places him into victimization, prejudice, and also people related to Mr. X. Because now, and also what it has done is that it has obstructed the commission from a potential, you know, unveiling of further information, because nobody would want to come and testify if they say, you know what, my name is Stanley and I would like to come and testify to the commission. However, I want my identity to remain anonymous. Then someone goes and mentions me. I won't go there. I have family. I don't want to be victimized. I have a business to run. So if I am known as that whistleblower and my identity is out there, then really, you know, the protection, you know, the protection of witnesses, the protection of whistleblowers in South Africa entirely is an issue. You know, I can just even give an example, even with the criminal justice system, even with the bail justice system. For you, in order to get bail, if there's a witness in the alleged crime that you committed, you need to prove to the court that there's no likelihood that you'll go and intimidate that witness. So really, we cannot downplay the protection of witnesses or whistleblowers, especially in state capture, because here we're not just talking about, you know, shoplifting. Here we're talking about serious things. And
serious allegations.
Exactly.
Now let's delve into Mr. X here. Does this mean that he'll have to go under some sort of witness protection, him and his family? Is his life in danger now that his name has been mentioned in the commission?
You see, based on the order that was made by the commission, one can readily conclude or argue that his life is in danger, and the life of his family members or people that is related to is also in danger. Because the commissioner would not have made an order if it was not satisfied that releasing or revealing the identity of Mr. X might be prejudicial to him and to the commission. So, yes, and now we're trying to think, like, where's the commission standing now? What the commission needs to do now is that it needs to take a decisive decision on this matter. Because here's the thing, this is not a common law offense. This is statutory. The law is there. We have Section 5 of the Commission. We have Regulation 12. It is very clear on what happens when someone intentionally obstructs, you know, obstructs the Commission. Not only that, Section 12, subsection 1 of the regulations also goes further to say that any person who belittles the Commissioner is guilty of an offense. Now, if I put it this way, disrespecting the order of the commissioner is tantamount to belittling the commissioner. Because here you are saying, oh, the commissioner has made me aware of this order. I don't care. I don't respect the commission. I'm disregarding it. I'm going to name X either way.
And that speaks generally to her general conduct throughout her standing on the main chair at the commission. That truly says that what will come out of Monday's, her legal team's argument on Monday will probably not be able to stand at the commission.
Yeah. And you know what's the interesting part? You would have seen that at the beginning, at the starting days of her testimony, right? Her legal team came out to argue that she's actually testifying with an X on her head. Because a lot of people who testified at the commission 2 days or a day after the Hawks were knocking at their doors. So now it is very ironic that this person who's testifying with an X on her head then takes a chainsaw and put it on somebody else's head.
Well said, Stanley.
So really, we need to balance things here. You can't fear for your own safety and put the safety of another person in jeopardy, especially if there's a court order in place. And especially, you know, just given the attitude on its own. I don't want to incriminate myself, so you want to incriminate others, or you want to place others into danger.
Does that make it okay? Yeah, that's the question.
Yeah,
Stanley?
And she was saying that no, Chair, I'm sorry, I didn't mean to disrespect the commission. But here's the thing, my brother. Sorry, it is not a justification for a criminal offense.
Too little, too late, Stanley.
Exactly.
We'll have to leave it right there. That's all the time that we have. That was
Sure.
Stanley Malimacha, attorney at the Center for Applied Studies, Legal Studies, speaking to us about the Dudu Myeni case, the delinquent director, or delinquent CEO, who appeared at the State Capture Commission of Inquiry a few days ago.